Okay, picture this, a half-finished skyscraper, a brand new power plant that's still offline, or a bridge project that's just stopped. In the crazy high-stakes world of construction, these massive projects are like complex machines. Every single day costs a fortune, so when million-dollar arguments break out, they absolutely cannot afford to wait years for a court to solve it. So that brings us to the big question, right? How on earth does an industry that lives and dies by planning and precision solve a huge, potentially project-killing fight in less than a month? Well, the answer is a really clever bit of legal thinking, designed for one reason: to keep the world building.
Now, to really get the solution, you've got to understand the problem it was built to fix. And in the world of construction, it all boils down to one simple thing: money has to keep moving. Cash flow really is the lifeblood of any project. Think about it. The main contractor has to pay the subcontractors, who have to pay their suppliers, who then have to pay for the actual materials. It's like a financial domino chain. If just one of those dominoes falls, if one payment gets held up in a dispute, the whole project can grind to a halt, and you can have multiple companies facing bankruptcy almost overnight.
And this really shows you the corner the industry was backed into. The old way of suing someone in court is just painfully slow and incredibly expensive. It could put a project on ice for years. So the industry desperately needed something different, a kind of rapid response team to get the cash moving again, even if the decision wasn't the absolute final word on the matter.
So what did they come up with? What is this powerful tool that can slice through these super complex arguments with such incredible speed? Well, let's dive into the world of construction adjudication, a process that is all about speed and getting things done.
This quote from Lord Justice Jackson really nails it. Adjudication isn't just a quickie trial or a faster version of arbitration. When he says it's sui generis, that's a fancy legal way of saying it's in a class of its own, it's totally unique, a special tool built for a very, very specific problem. So here's the gist of how it works. In places like the UK, this process is actually written into the law. You bring in an impartial expert, the adjudicator, to look at the dispute. And their whole job is to make a decision, fast, that's binding, at least for now. The goal isn't some perfect final form of justice. It's about getting a practical, immediate answer so everyone can get back to work.
And when I say fast, I mean fast. The whole thing kicks off with a formal notice, and then one side submits all their details and evidence. The second that happens, a clock starts ticking. The adjudicator has just 28 days, 4 weeks, to look at everything, ask whatever questions they need to, and issue their decision. It's an absolute sprint.
But to really, truly understand why this whole thing works, you have to get its core philosophy. And honestly, it's incredibly practical. This one phrase, pays now and argues later, is basically the mantra of construction adjudication. It perfectly sums up the entire spirit of the process. The number one priority is to get the money paid and keep the project moving. All the deep, complicated legal arguments? Yeah, those can be sorted out later, in a proper court or arbitration, without holding the entire project hostage. The best way to think about it is like a referee's call in a big soccer match. The ref makes a call right there on the spot. Maybe it was the right call, maybe it was wrong, but the call stands and the game keeps going. You can't just stop the entire match for half an hour to have a big debate. Adjudication is that on-field call. It's sometimes called rough justice because it's not trying to be legally perfect, it's about making a quick, workable decision to keep the game moving forward.
Okay, so you're probably thinking, wait a minute. If a decision is made that fast, and it's only temporarily binding, what stops people from just ignoring it if they don't like what the adjudicator said? And that is a fantastic question.
So let's look at what happens when one side is absolutely furious with the decision and just decides, nope, I'm not paying.
This is where the courts get involved, and their role here is so important. As a matter of public policy, courts are big fans of adjudication. So when a winner comes to them to enforce a decision, the court's job is not to listen to the whole case again and decide if the adjudicator got it right. Nope, their job is simply to enforce the decision that was made.
The reasons you can challenge a decision are incredibly narrow. You can't just go to court and say, the adjudicator was wrong. It doesn't work like that. You have to prove there was a major flaw in the process. Like, did the adjudicator decide on something they weren't even asked to rule on? Or was one side not given a fair chance to state their case? The whole focus is on how the decision was made, not what the decision was.
So the bottom line here is really, really important. Just being mad about the result is never a good enough reason to not pay up. The whole system is designed to be tough and enforceable to protect that all-important idea of pay now, argue later. Now, this powerful idea of getting quick, temporary decisions hasn't just stayed in one country. Its success has basically become a blueprint for huge projects all over the world.
The basic philosophy has been so successful that it's been built into the standard contracts for massive international projects. We're talking about the kinds of contracts used to build dams, airports, and railways that connect entire continents.
And you see a few different flavors of this around the world. In those big international contracts, you often see something called a dispute adjudication board, or a DAB. One of the main differences from the UK model is that you agree to have a DAB in your contract. It's not usually required by law. And a lot of the time, the board is appointed for the entire project, which is great because they get to know it inside and out and can often help solve problems before they blow up.
And the money this saves is just staggering. Solving a problem with a dispute board costs a tiny, tiny fraction of the project's value. But if you let that same problem escalate into a full-blown international arbitration, you could be looking at costs that are exponentially higher. The savings in both time and money are just enormous.
But the core principle is exactly the same. The DAB's decision is binding. You have to do what it says. Now, if one side is still really unhappy, they can issue what's called a notice of dissatisfaction. That gives them the right to take the whole dispute to arbitration and have it heard all over again, from scratch. But, and this is the absolute key, in the meantime, they still have to pay.
So, to wrap this all up, adjudication is really the construction industry's common sense answer to a problem that could be crippling. It's a system that's okay with a little bit of rough justice in the short term, all to achieve that much bigger goal of keeping the money flowing, keeping people in their jobs, and keeping our cities and infrastructure growing.
And that leaves us with a pretty interesting question to think about. In a world that totally depends on these complex, expensive, time-sensitive projects, is this system of fast, sometimes imperfect decisions not just a clever idea, but an essential price we have to pay for progress?